From the publishers of Fair Housing Coach, meet property manager Paul. Paul works for a property management company and encounters many of the same issues you do. Paul has a tenant named Julie who has a developmental disability that affects her capacity to manage her own finances. Julie informed Paul that her mother will be paying her rent for this reason and asks if all notices relating to her rent can be sent to her mother. Paul recalls his management company having a policy of sending notices only to residents, but decides that not obliging Julie's request would be denying a reasonable accommodation, which is a form of disability discrimination. HUD recognizes reasonable accommodation as a change, exception, or adjustment to a rule, policy, practice, or service that may be necessary for a person with disabilities to have an equal opportunity to use and enjoy a dwelling. Since rules, policies, practices, and services may have a different effect on persons with disabilities than on other persons, treating persons with disabilities exactly the same as others will sometimes deny persons with disabilities an equal opportunity to enjoy a dwelling. If Paul had refused to send the rent notices to the tenant's mother as requested, and the rent increased without the tenant's knowledge, the tenant might have received an eviction notice. In this case, she would be right to file a complaint with HUD because denying a reasonable accommodation is a form of disability discrimination. Get more information about fair housing compliance by going to www.fairhousingcoach.com/subscribe.